Hello, everybody, and thank you for being here. My name is Alexandria Cawthon, and I am your VP of HR. It is nice to be able to see you all today, but I did want to let you all know this is going to be recorded, and we will have the notes sent out after, and I'll maybe mention that again here in a little bit as a reminder. But the purpose for our meeting today is to cover some basic employment law information that's important for every people leader to have and know. I know this isn't everyone's favorite topic to sit through. I'm in HR and it's not mine either, but it is important. So I will do my best to keep it engaging and clear of what you need to take away and focus on. Being a manager, it does sound fun to most, but with great power does come some great responsibility. So this is a brief agenda of what we'll be covering today. I know it's a lot, but the key things I want you to take away here is we'll talk about equal employment opportunity, pay specific law, medical and safety related items for you to know, union related items to consider, and then finally there's just a couple there that I think are good for you to know about, but I don't think you'll have to remember all the time or keep fresh of mind. Now, I do want to go ahead and let you know, for those of you that are more detail oriented or like to take notes, this is your cue to go ahead and get your pens ready, or if you want to take them on your computer, feel free to do that as well. But like I said, you will have these slides and the notes afterwards as well. So why should you care? It's kind of the classic piece there. So I did talk about earlier, with great power comes great responsibility. And you might be thinking, well, I have to do this because I have to. That's all it is. And you're not wrong, but I think it is also important to call out the real reasons. So, first, if we don't pay attention to what the law tells us, that can get the company into some pretty big trouble really quickly. It could be paying big bucks for damages, which can ultimately sometimes impact the company's budgets. And unfortunately, that can also mean your bonuses. So it is hugely important from a cost standpoint. But second, and actually more importantly, it's the right thing to do. And diversity brings in better and more innovative ideas while making us a stronger company overall. I'm going to jump into the content. So, again, make sure you've got those pens ready to go. So I know it's a lot here. So if you would prefer to just listen to me, focus on me, but I wanted to make sure the content was here for you to review later and it all still makes sense. But for the first section here, we're going to get into equal employment opportunity. And the first is, you might see that Civil Rights Act note there. And I did put in parentheses Title VII. This might be how you will recognize this term. But what it is it protects employees from discrimination based on their race, color, religion, sex, and national orientation. This does also protect candidates that are applying for jobs. It provides a safe space where diversity is encouraged and is a catalyst for more innovation, as I talked about a minute ago. So, what are you responsible for? You're responsible for reporting any discriminatory actions or statements, even if it's a joke, to HR. You're not to consider someone's race, color, religion, sex, national origin, when making business-related decisions such as hiring, pay, etc. The next we'll talk about is the Americans with Disabilities Act. This act protects employees and applicants, again, from discrimination against them for reasons associated with their seen or unseen disabilities. This one is tricky because there can be some disabilities that you just can't see and you don't know that someone has. And it is also the law that relates to reasonable accommodations. That might be something you've heard before. Reasonable accommodations, they may need to have those if there is a worker that is disabled, for an adjustment to their schedule, responsibilities, time off, or specific equipment to set them up for success in their job. This is also a sensitive situation. You are not to ask someone if they have a disability. If they come to you and they ask for an adjustment to their work for those reasons I mentioned earlier, due to their ability, contact HR immediately for support through that process. There's some paperwork involved, but I don't want you to be asking them for information, or if they're disabled, that can get you into that hot water. So again, just know if someone mentions a medical disability, whether you see it or not, or they ask for an accommodation and they might not use those words, contact HR immediately. So have your listening ears on. There's also the Pregnancy Discrimination Act. So some people might think this fits into the disabilities piece. It does not. It's separate, but it's still important. So this act is there to protect those employees and applicants from discrimination based on pregnancy, birth, or any other related conditions. So again, that cannot be a determining factor in important business decisions such as pay, hiring someone, those kinds of ideas or reasons, excuse me. But again, please contact HR if you're ever curious or just not sure what to do. Now, lastly, here is Age Discrimination in Employment Act. This protects employees and applicants over 40 from discrimination due to their age. Now, again, do not ask someone their age. While it's rude, just don't do it because of this act as well. It can get you into that hot water. And do not make any decisions based on someone's age alone. A lot of factors there. While most of us don't know each other's age, that should be good. But again, be very careful not to assume someone's age and be very careful not to make decisions based on someone's youth or oldness. I'll say it that way, okay? Make sure that you're focusing on their ability to do the job. Now, to wrap this section up, I do want to also ask you, when you're working through your job descriptions or if HR is asking you for job-related questions or specifics, make sure you're very clear on what the qualifications are for a position. What are the required things that that candidates have to have? And any preferences of yours, it's okay to list as preferences. But if you ever list something as a qualification or requirement, those are hard and fast rules. If you start dancing outside of those rules for one candidate, that means you cannot have hard and fast rules for another. You have to treat everyone equally. Now, that is where HR can help you. So again, contact us and we can help, but just make sure you're very clear and specific. If you ever need to talk about a job or an opening or something of that nature, we can talk about the job description and what exactly is required, what qualifications are needed. It's okay, again, to list those preferences. These are used in legal situations. So a job description and job posting, those are technically open for legal review and we can be held to those standards. So if we start working outside of those, that's why I'm harping on it, it can get us into that hot water. And finally, to end here before we jump off, do not make any decisions, again, based on hiring or pay or promotions or anything that has to do with someone's position based solely on their body, pregnancy, health, etc. If you're concerned or have questions before you mention it to the employee, call HR. We'll help you. Ultimately, what are we trying to avoid? So yes, of course, we're trying to avoid paying, but we also want to avoid discrimination, harassment, retaliation. Ultimately, we ask you to follow these laws to avoid these things, but most of all, we want you to have a clear understanding that discrimination is wrong. However, harassment, it's not always clear. Most of us know discrimination isn't okay, but harassment, sometimes we think something could be just a harmless joke, but intentions do not always matter. So if you don't intend for something to hurt someone's feelings, there we go, that doesn't always matter, and the law doesn't always care. So regardless of if you intended it or not, the outcomes are ultimately what matters. So a harmless joke to you is not always harmless to someone else who might be on the receiving end or hears it. Finally, if someone makes a complaint, you cannot retaliate against them. This is crucial to understand and learn how to regulate your emotions. You might hear something, you might feel like it's a personal attack on you. If someone feels as though they need to make a complaint against you for whatever reason, but you need to keep those emotions and opinions to yourself and in check. If you need to come talk to someone, come talk to us in HR. We can be there to listen. But as far as emotional intelligence, that's for another class. Might be more fun, but that's another time. Okay, you take a sip of my tea. Okay, for Equal Pay and Fair Labor Standards Act. So we're going to be talking about money a little bit here. The Equal Pay Act provides a workspace where it's fundamental to ensure there is pay equity based on the merits of someone's performance, experience, or in some cases, seniority, regardless of their gender. There are times where pay may be similar, or I'm sorry, pay may differ for similar work, but it should only be reasons that circle around someone's merit or seniority. So again, equal pay for equal work, but there can be times where it's different, even if it is similar work, but it has to be based on their merit or seniority. Now, to ensure we don't have pay disparities that creep up, there are pay equity reviews that HR can do. It's some due diligence on our part to help make sure that that doesn't happen. So if you ever want to make a pay adjustment, just reach out to us and we can help review that for you. Now, FLSA, or Fair Labor Standards Act, that was created to establish, and this is a direct quote, to establish minimum wage, overtime, pay record keeping, and youth employment standards. So that is directly from the Department of Labor. But after 40 hours of work in a work week, overtime pay is required at 1.5 times the employee's regular pay rate. Now, there are some states where that's slightly different, like California. They're always different sometimes, right, with these employment laws, if any of you are familiar. But for our case, this is true. So over 40 hours, employees are paid at 1.5 times if they are hourly or salary non-exempt, but we'll talk about that here in just a second. But there are clear guidelines that determine if a job can be exempt or non-exempt, meaning exempt from overtime, meaning salary, they're not going to get to clock in, clock out, they get paid what they get paid, or non-exempt from overtime, meaning they're eligible to receive overtime. It's a little hard to understand. It feels counterintuitive, but you cannot determine if someone is salary because you want them to be. There are clear, specific job qualifications and job requirements to dictate if a position can be salary and not clock in and out. Now, it can get tricky, so just contact us. That's kind of the theme here. Reach out if you're not sure before you make those big decisions. But you cannot dictate if a job is eligible for overtime or not. It's based on their responsibilities, and if you're noticing considerable overtime use, reach out to us. That could mean we need to maybe talk about additional headcount or labor support for whatever might be going on, because it seems like there could be more work than staff to support in those situations. And again, best practice here is to make sure that you have clear specifics in your job qualifications, requirements, and preferences, and consult us in HR before making pay decisions. We can help keep you out of those troubles. All right, shifting gears into the more medical health and safety space. Now, FMLA, or Family Medical Leave Act, is a protection for an employee's position and medical benefits for up to 12 weeks. It is unpaid, or can be, and it covers specific medical conditions for themselves or certain family members or for certain military situations. Talk to us if an employee mentions any of these things or needing to be out for a period of time due to medical reasons or for extended periods, and do not ask the employee to share any of their health information with you. That's a big no-no there. What you can do is, in preparation for someone to be on leave one day, because one day it will happen if you're managing people long enough, consider how can you backfill them or cover their work while someone could potentially be out one day. What's your backup plan? For OSHA, or Occupational Safety and Health Administration, most of you should know this in our manufacturing environment, and I hope you know it by heart, but as a refresher, and this is directly from the Department of Labor, OSHA is there to ensure safe and healthful working conditions for workers by setting and enforcing standards and by providing training, outreach, and education and assistance. Now, you as a manager are to record and treat any injury or illness as if it is work-related. This excludes first aid injuries, of course. Now, if the worst was to happen, and let's hope and really pray that this never does, but you must also report any worker fatality within 8 hours and any amputation, loss of eye, or hospitalization of a worker within 24 hours. Now, if you don't feel like you can remember those things, just realize that if anything was to happen that is a major work-related injury or illness, contact HR and Health and Safety immediately, and we can make sure to get everything recorded appropriately or help you with that. Now, finally, these are union-related laws. We wanted to put them together. So one is more employer-focused, one is more union-focused. But the first is National Labor Relations Act, or NLRA. So this holds employers to standards not interfering with unions. So obviously this is the pro-union side. That's okay. So we're not to interfere with them or their activities, not discriminate against those that participate in union activities or those that file claims, and practicing good faith in union bargaining with them. Now be careful not to interfere with union activities or organizing events. If you hear of union organizing activity in other plants, contact HR immediately. We can get in there and try to figure out how we can best support, but do not take adverse action on those participating in any union activity of any kind. Next is the Taft-Hartley Act, or the more employer-focused. I want to cover a few items here, but it requires unions to bargain in good faith with us as well. It protects employees from unions discriminating against them and restricts union activities such as strikes. It also is stated that joining a union cannot be a determining factor when hiring someone. So those guidelines are in place to make sure employees and operations all feel protected. Now, working with unions in good faith and fairness, the reason for this is it supports a more positive working relationship with them and potentially more beneficial when it comes to bargaining activities or contract negotiations. So again, contact HR if you receive any questions or if you have any concerns, and we can give you any guidance on your specific situation that you encounter. Now, these are the last two that you may one day come in contact with, but let's hope you don't come in contact with the last one. I hope we don't either. But the first is ERISA. So ERISA, it provides protection for employees when it comes to retirement benefits and comfort that the plan that they're in within the company will be maintained and managed effectively. I think we all probably have plans within the company and we want to make sure that they're maintained well. So there is a law there to protect all of us. You should ensure your employees feel comfortable finding retirement plan benefit information or who their contact is and benefits their HR. You are not to give them any benefits advice. That is a clear line that you have to make sure not to cross. Can get you in hot water. And you do not have the ability to determine or change an employee's retirement benefits, but that should go without saying. Now, lastly, the WARN Act. Again, let's hope we never encounter this, but it does provide 60-day advance notice to employees of a plant closing and or mass layoffs to give them time to adjust and determine their next steps. It gives the ability for the organization or us to determine alternative positions for impacted employees and be there for them to support their decisions. So that's a hard time. It usually impacts their well-being. So we have to make sure, and we want to give them, I know the law makes this, but it's important. If that is to happen, we want to have those 60 days to figure out a way where we can be there and help them through that adjustment period, or maybe find them a different position. Now, you are responsible for caring for that employee's emotions and the emotions of the team during that time. It can be a highly volatile and emotional moment, and you as the manager are responsible for guiding the team through that. So have empathy and then share any relevant information with the impacted employees from HR or leadership. And we'll guide you if that ever was to happen. So again, let's hope it doesn't. But we hope this never happens, and we're thankful that such a law exists for our own personal reasons as well. Okay, so we've reached the end. So hopefully no one nodded off, and I understand if you did. So I want to make sure you know this is recorded and the notes are available because this is crucial for you to know. So if you ever need to reference something, this will be posted on our HR site. You can go here first. I'd love for you to call me first or contact your HR rep. But we're more than happy to answer any questions that you have. Feel free to reach out. My name is here on the slide, Alexandria Cawthon. You can find me in the system. We're always happy to help, but please think of HR as a partner. We want to support. We're not here to be red tape. We want to help consult and not be the HR police. So hopefully we get to talk to you soon. And if you are curious or want more information, this is a list of the resources used today. Thank you so much and have a great rest of your day.